Okay, abusuya be makwaba sonko so edeba POG Media so. Abusuya yembonra eye yensemu no. Eye Chief Justice Petitioner eye John Dramani Mahama sisi ano yede babe remove eye Chief Justice Torkono every eye ne position hono. Na sisi anentia yenya ne se eye John Dramani Mahama ebe appoint eye lawyers Tsatsu Tsikata ono NSCC ano obabeye the Chief Justice of a Supreme Court abusuya eno NHS yede ato ye screen no enchen de amamono na sa source we every Esther Ayinsu insider of the presidency ono no odi ni dwuma ewo Facebook ono NHS odisa intel we e de abreye intino lawyer Tsikata ono NHS ano sake a yebe sake Chief Justice Torkono ono eba besi na name as Chief Justice of Supreme Court. Yes, no sa breaking news we ena HSA yede abrem medamase.
Morning here on Key Point. It's one that also a number of you followed and generated conversation, but there's a development that also is instructive because of what the president also did yesterday. We got notice of his decision to, as it were, bring the Chief Justice's notice to the details of the petition, 3 of them against her, and asking for her removal. Prior to that, a number of things had happened, and this was the beginning of what ensued in the last 3 to 4 days. We got notice of this particular information assigned by the Minister in charge of Government Communications, Phyllis Kwachu-Fosu, Tuesday night. We'll put that on the screen. This is the statement that came from him indicating that President Mahama had received 3 petitions from various persons seeking the removal of the Chief Justice. The President, per the statement by Phyllis Kwachu-Fosu on Tuesday, had forwarded the 3 petitions to the Council of State to commence the consultation process mandated by Article 6 of the 1992 Constitution. After this statement from Phyllis Kwachu-Fosu, which some say that, well, it shouldn't have been put out in the first place. There's a more the view that this publication or this statement from him detailing the existence of these 3 petitions was not needed. We'll come to that, whether there's merit in that argument or not. Afterwards, a member of parliament for the Old Tafo constituency on the ticket of the MPP went to court after a couple of days, asking fundamental questions as to why the Chief Justice has not been put in notice of the details of the said petitions against her. This was what Vincent Tasefua went to court asking with his lawyer, the immediate past Attorney General Minister of Justice, Godfrey Yeboah-Dame. He says that they want a declaration that upon a true and proper interpretation of Article 146 and 296 of the 1992 Constitution, the President is mandated, and take note of the words, is mandated to notify the Chief Justice about a petition for the removal and solicit her comments. Well, he also sought a declaration that failure by the President to notify the Chief Justice and obtain comments violates Article 146 and protection of the security of tenure of the Chief Justice. Declaration that failure by the President to notify the Chief Justice amounts to an unjustified interference with the independence of the judiciary. So then questions started coming up as to whether there is an explicitly defined timeline as to when the President should notify the Chief Justice of petitions against her under Article 146, Clause 6 of the 1992 Constitution, which we will get into. Because that is really the crux of some of the issues, the reliefs that Vincent Tasefua was asking in court. He was not the only one. It was another citizen who also went on the same path. So there were two petitions, as a matter of fact. The second one was asking that the entire process even be halted and thrown out because, per the argument of the said individual, this entire process of the president forwarding the petitions to the Council of State without necessarily having the Chief Justice see the details of the petition violates Article 1466 of the 1992 Constitution. Then later, the question was asked, how did Vincent Assefuwa get to know that the Chief Justice, as of Thursday, was not aware of the details of the petition against her? Well, that question was answered later that day when the Chief Justice herself wrote to the President and the Council of State asking for copies of the petition against her. And that was also made public, so we got some copies of it. This is what she was asking for. Put that on the screen. To the extent that no defendant can be subjected to a trial unless the preliminary process of receiving their response has been adhered to. And up to date, that was March 27, 2 days ago, the Chief Justice at the time had not been shown the petitions or allowed to respond to them. She also at the time had made the point that the combination of evidence in the petition and the response of the Chief Justice will provide material for consultation between the President and the Council of State. Forward petitions and give at least, she was asking for 7 days after receipt of petitions to provide response. Well, afterwards, yesterday, the President also responded to some of these concerns that the Chief Justice raised and expressed disappointment in the position that the Chief Justice had taken, that he already, as President, had put the measures in place to have her get copies of the petition against her even before she came out. And even though the Chief Justice was asking for 7 days, the President has given her 10 days as of yesterday to respond to the details of the petitions, 3 of them against her. I've been joined in studio by Christian Mamhesi, who is a private legal practitioner, constitutional lawyer as well, joining us right now. Christian Mamhesi, good morning. Thank you for joining us.
Good morning. Thanks for having me.
You had the view that to the extent that the Chief Justice had not been notified as of the time, that on Thursday, she essentially had a case. Why is that?
Yes. If you look at Article 146 carefully, it does not provide for procedural time limits, at which point in time various actors need to play their role. But if you also avert your mind to the case of the Frank Chum case versus Attorney General, Dateba eruditely expounded on these points. Now, averting our minds back to Article 146, and generally as most Ghanaians have become lawyers now, Article 146 is the trending factor. President has received the petition and subsequently would forward it to or seek advice from the Council of State. At that conjunctive time, if you assess Dateba's erudite exposition as far as his judgment is concerned, his lead judgment is concerned in that case that I referred to, he goes on to indicate that there should be a prior determination with consent to the Chief Justice before a prima facie case is laid out. So that seeks to say that the Chief Justice must have an input in terms of response to all of that, so that where the prima facie is supposed to be determined, furthering on would be for the hearing of the matter. So that Eba puts us in a chronological development of how things should pan out. Now, the learned jurist admits that procedurally there had been some omissions that the framers of the Constitution, and he terms it as inadvertence or a mistake.
Right.
Now, when that happens, jurists or a position of the law requires that judges can do what we call filling in the gap. And filling in the gap would be that judges would construe the Constitution as a living document. And we had seen this espoused in a number of cases. If you look at Salah versus Attorney General, you look at the Ghana Bar Association versus Attorney General, you also look at the one of the important cases in constitutional law where Adade JSC indicated that the Constitution must be, the Constitution is not a penal code, but that its construction must be liberal and reflected in the light of societal and political development. So the Constitution is largely considered as that, so that if the construction or interpretation of it would render provisions of it absurd or incorrigible, then it will not serve the purpose for which it was put out for. Now, in the construction of it thereof, we have two things that we consider. We have the objective purpose and then the subjective purpose. The subjective purpose deals with what the framers, what they intended. And then the objective purpose, as Dateban indicated, deals with the hypothetical author of the Constitution. And that is where judges put themselves in to consider what it should be. Now, it is just not about that with respect to the objective purpose. He further went on to explain that in the objective purpose, we look out for the core values, the legislative history, the legal systems, and that puts us into the spirit and context of the law. And the two must be balanced in order to come to that position. Now, and in coming to the position, you would realize that it would be incorrigible to say that the Chief Justice is not given the opportunity to be heard. Now, if you further read the judgment, it says that the Council of State must evolve with by a convention in dealing with procedural matters as far as the removal of Chief Justice, or generally speaking, with respect to Article 146 is concerned. This would be my preliminary comment.
I see, but to the extent that you also agree, the earlier point I made, that there is no explicit timeline as enshrined in Article 1466 of the 1992 Constitution as to when the Chief Justice should be notified during the process of consultation. If you look at the President's statement, he references that to the extent that the process was in its elementary stage, he already had started the process of consulting the Chief Justice, even before she came out to say, I have not been consulted. As far as we do know, the petition was brought to the public notice as of Tuesday. So the Chief Justice writes maybe about 48 hours after that public notice that I have not been informed. Would you agree with those who say maybe she just went ahead of herself and that to the extent that there were no timelines to when she was supposed to be informed, this was going to happen anyway. And it has happened as of yesterday.
Yes. I must comment and say that it was quite unfortunate that this whole thing came out in the public sphere. Again, I keep citing Dr. Dateba because he gave the lead judgment and was supported by other judges, including Justice Isiama and all that. As far as Article 146 is concerned, matters are to be heard in camera. That means that it's supposed to be private, so that by the position of the law, the judiciary, it does not put the judiciary in a negative light, where judges will be slighted here and there, and render the institution of the judiciary down. So that is the reasoning behind that particular clause under Article 1468. Again, the Chief Justice cannot be faulted because, having heard the matter all over in the public sphere, she would not know the time the petition went through, and for whatever it is worth, and especially with hindsight of law, she only put in a letter trying to enforce her conjunctive rights under the Constitution of natural justice, that indeed this is what I have heard in the public sphere. And it would only be fair that if such a thing has gone through, give me the opportunity to be heard. And that's what happened. If it was a situation that it was strictly carried out in accordance with Article 1468, this would not have happened. The Chief Justice would not have written, because she would not have known. But once it's in the public sphere, she had every right to apply to the presidency to register her interest to respond to it, as is deemed by natural law. Again, before you come in, with respect to such publications coming out, I mean, in respect to petitions coming out as publications, Dateba seriously criticized that and indicated that that's with respect to Bright Akwite's case in the removal of the Superior Court judge, and indicated that it breaches against the purpose for which the Constitution, that particular constitutional provision, Article 1468, was put out, in that it is meant to be in camera, and all other supplementary documents that will be traded between institutions until the closure of the matter must remain in private.
I see. So you raise concern, you also side with those who have raised concerns about the statement as issued by Phyllis Kwachofosu Tuesday, given the public notice of the existence of these 3 petitions against the Chief Justice. That is what has spiraled all of this. Okay.
For me, again, authorities speak to the that, save that Justice Dateba commenting on this privacy and the breach of it thereof, indicated that to mention that there is a petition against a sitting Chief Justice, fair, but to put the content out, and in that situation, the content of the petition was put out, and indeed, it was obvious from him that he was even going to copy other institutions aside the presidency of the content of the petition. But in this case, that's not what necessarily happened. The content of it still remains intact, but it is only the spiral nature of the petition going out. It cannot be said that Article 1468 in terms of privacy has been breached because the content is not known by Ghanaians. But once she has heard that this is the situation, she was only putting in or registering her right that if indeed this is anything to go by, let me be heard.
And Lord Matibebo, in principle, the argument is that they.
Okay, Abusia winner and some also a political highway. So, a Chief Justice Torkono right now, a lawyer Tsatsu Tsikata, ono NHS or Babaye, the new a Chief Justice Abusia, Yede Ebremo, Yabramasi Samojepini, Kokotisa, Otuwi, Edimai, aha, APOG Media, so, Bramase.